दोस्तों इस क्लास में आपको डिक्टेशन दूंगा मैं 100 WPM पर 600 वर्ड्स की डिक्टेशन है, आपको डिक्टेशन में प्रोवाइड कर रहा हूं। बी रेडी फॉर इट।
The challenge in the present appeal is to an order passed by the Division Bench of the Kerala High Court, whereby it was held that Section 14 of the Securitization and Reconstruction of Financial Assets and Enforcement of Security Interest Act, mandating the district magistrate to deliver possession of a secured asset within 30 days time, extendable to an aggregate of 60 days upon reasons recorded in writing, is a directory provision. The Act was enacted in the year 2002 for reasons that the legal framework relating to commercial transactions had not kept pace with the changing commercial practices. Further, financial sector reforms resulted in a slow pace of recovery of defaulting loans and mounting level of non-performing assets of banking and financial institutions. The objectives behind the Act recognized that unlike international banks, banks and financial institutions in India did not have power to take possession of securities and sell them. The provisions of the Act were upheld by this court except that of subsection 2 of section 17, which provided that the debt recovery tribunal shall not entertain an appeal preferred by a borrower unless 75% of the amount claimed has been deposited before it. Thereafter, the question as to whether the withdrawal of an application filed under the Recovery of Debts Due to Banks and Financial Institutions Act is a condition precedent to take recourse to the Act was examined by this court. This court observed that when civil courts failed to expeditiously decide suits filed by the banks, the Debt Recovery Tribunal Act was enacted. However, it did not provide for assignment of debts to securitization companies. The Act, which was enacted thereafter in 2002, sought to further empower the banks and facilitate the recovery of debt. It proceeded on the basis that once the liability of a borrower to repay crystallizes, it becomes due, and that on account of delay, the account of such borrower becomes substandard and non-performing. The argument of the learned counsel for the appellant is that the proviso mandating the district magistrate to record reasons if the order is not passed within 30 days in order to avail an extended period of a total 60 days shows that the provision is mandatory. If the district magistrate is not able to take decision within 60 days, the secured creditor has to found its remedy elsewhere and not in terms of section 14 of the Act. It is contended that the proviso mandates the district magistrate to pass an order within 30 days as the word shall is used in first part of the proviso. Thus, the time limit provided is unambiguous and by corollary the provision is mandatory. A well settled rule of interpretation of the statutes is that the use of the word shall in a statute does not necessarily mean that in every case it is mandatory, that unless the words of the statute are literally followed, the proceeding or the outcome of the proceeding would be invalid. It is not always correct to say that if the word may has been used, the statute is only permissive or directory in the sense that non-compliance with those provisions will not render the proceeding invalid, and that when a statute uses the word shall, prima facie it is mandatory, but the court may ascertain the real intention of the legislature by carefully attending to the whole scope of the statute. The principle of literal construction of the statute alone in all circumstances without examining the context and scheme of the statute may not serve the purpose of the statute. दोस्तों इसी के साथ ये डिक्टेशन फिनिश होती है। उम्मीद है आप लोगों ने इसे अच्छे से किया होगा। पीछे की डिक्टेशंस भी आपने अच्छे से ही की होंगी, ये मुझे उम्मीद है। आप प्रैक्टिस करते रहिए लगातार माफ़ कीजिएगा। जो भी दिक्कत आपको हो रही है शॉर्ट हैंड को लिखने में है या किसी वर्ड में, आप कमेंट सेक्शन में बता सकते हैं। अपनी जो भी आपके कमेंट्स हैं, जो भी सजेशंस हैं, आपको अपना कमेंट सेक्शन में बताइए। मैं पूरी कोशिश करता हूँ हमेशा कि आपको रिप्लाई करूँ, तो आप बस मेहनत कीजिए। ये मेरा हमेशा से यही मोटिव रहा है कि आप लोग ज़्यादा से ज़्यादा मेहनत करेंगे तो जॉब लगने के चांसेस उतने ज़्यादा बढ़ जाएंगे, है ना। तो आप बस मेहनत करते रहिए। मैं कोशिश करूँगा आपको इसी तरीके से डिक्टेशन प्रोवाइड करने की। आपसे मैं मुलाकात करूँगा अब अगली क्लास में अगली ट्रांसक्रिप्शन के साथ। तब तक के लिए बाय बाय, टेक केयर।